Hey, I'm Alex Rivera, and I need to tell you something that's going to sound like I'm fear-mongering, but I promise you I'm not. I'm just reporting what I've been watching happen in the AI ecosystem for the last 18 months. Here it is. If you're a freelancer, consultant, or contractor using AI tools like ChatGPT, Claude, or Gemini to power your client deliverables, you're walking into a legal liability structure that's completely asymmetrical. And the worst part, you won't see it coming until a cease and desist letter shows up. Let me be specific. Last year, I worked with a freelance UX designer, smart person, solid portfolio, did work for mid-market SaaS companies. She'd been using Claude Opus to help her generate design system documentation and accessibility audits. One day, client's legal team discovered that her AI-generated documentation contained exact phraseology from a competitor's design system. Not plagiarism in the traditional sense, it was in the training data. But here's the thing, the liability fell on her, not on Anthropic. She got hit with a $47,000 settlement demand. The client dropped her, and her insurance wouldn't cover it because AI-assisted work falls into a legal gray zone. This is the story I'm seeing repeat itself across the freelance economy right now. Let me start with the scale of this problem. According to McKinsey Q3 2024 data, 61% of Fortune 500 companies have deployed generative AI into their workflows. That's major enterprise adoption. But here's the gap. Almost none of those companies have updated their contractor agreements to address AI-assisted output. And on the AI company side, OpenAI is now doing approximately $3.4 billion in annual recurring revenue. Anthropic just raised funding at a $20 billion valuation. Google's Gemini Ultra is integrated into enterprise workflows serving thousands of companies. But none of these platforms have indemnification clauses that protect the freelancers and contractors using their tool. So who bears the risk? You do. Here's why this matters, and here's where most people get it wrong. When you use GPT-4 or Claude Opus to generate work for a client, you're not just creating content, you're creating evidence. That output is a digital record of what the model was trained on. And because those models were trained on internet-scraped data, proprietary datasets, and in some cases, copyrighted material without explicit permission, your output carries that legal baggage forward. I've reviewed dozens of AI platform terms of service over the last year, and I can tell you, not a single major platform assumes liability for the outputs you generate using their tool. Not one. OpenAI's terms explicitly state that users are responsible for the outputs they create. Anthropic's Claude documentation says you own the outputs, but they make no guarantee that those outputs don't infringe on third-party intellectual property. Google's Gemini terms are even more explicit. They reserve the right to use your conversations for training, but they don't indemnify you. So the legal structure looks like this. You use the tool, you generate the output, you deliver it to your client. If that output contains training data that was scraped from someone else's work, or if it's derived from copyrighted material, you are the liable party. Not the AI company, not the client if they didn't request it specifically. You, and here's the thing I've seen happen, clients are starting to understand this, so they're building it into their contracts. I reviewed a contract for a freelance copywriter last month. The client explicitly required zero AI-assisted content and included an indemnification clause that held the contractor liable if any portion of the deliverable was generated with AI tools. That's becoming standard. And if you're already using AI to power your workflow, you're potentially in breach of contracts you haven't even signed yet. Let me give you the numbers on what this looks like economically. According to a survey from the National Freelance Association in Q4 2024, 38% of freelancers are now using AI tools in their workflow. That's 38% of the roughly 59 million freelancers in the US economy. But here's the critical gap. Less than 4% of those freelancers have updated their contracts or liability insurance to account for AI-assisted outputs. We're talking about a massive exposure window, potentially $2 trillion in freelance work annually, with a growing portion powered by AI tools that carry unaddressed legal liability. Now, I want to walk you through specifically how this shows up in legal proceedings, because this is where it gets real. There was a case that came through late 2023 that's instructive. A freelance graphic designer in California used Midjourney to generate variations on a client's logo concept. The client loved it, deployed it across their brand, and 6 months later got hit with an infringement claim from an artist whose work was in Midjourney's training dataset. The artist claimed the generated logo was too similar to their original work. Now, the designer argued, "I didn't copy this, the AI generated it." The client argued, "We hired you to deliver original work, it's your responsibility." And Midjourney, they stayed silent. The case settled out of court for an undisclosed amount, but the designer paid 100% of it. That's becoming the template. Courts are starting to treat AI-generated outputs as derivative works, and the person who commissioned or delivered the AI output is treated as the author. The AI company is treated as a tool, and tools don't have legal liability. People do. So what does this actually mean for your contracts? I'm going to walk you through the specific language that's creating this gap. Most freelance contracts have a section that says something like, "Contractor warrants that all deliverables are original work created by contractor and do not infringe on any third-party intellectual property." That's standard language. But when you're using AI tools, that warranty becomes murky. Are you still creating original work if 40% of the output came from a language model trained on internet data? Courts haven't definitively answered that yet, but they're starting to rule in favor of clients, which means contractors are eating the liability. I've started advising freelancers to add a specific addendum to their contracts that addresses this. Here's what it looks like. Deliverables are created with assistance from AI tools, specifically tool name. Client is aware that these outputs may contain language patterns, structure, or concepts derived from the AI model's training data. Client assumes responsibility for conducting due diligence on final outputs before deployment. That's not perfect. Nothing is in this gray zone yet, but it creates a paper trail showing informed consent. Here's what I've seen work. Some clients actually appreciate this honesty. They know they're hiring AI-assisted work. They know it's faster and cheaper. They just want clarity on what they're getting. But other clients see that addendum and immediately request human-only work, which means they're not pricing in the AI productivity gain. Either way, you have clarity. Now, let me address the elephant in the room. Why are AI companies getting away with this? It comes down to how they're structured legally. OpenAI, Anthropic, Google, they all have sophisticated legal teams that have deliberately positioned their platforms as neutral tools. They're not authors of the outputs. They're not responsible for the training data in any indemnifiable way. They're just infrastructure. And because they're positioned as infrastructure, they have liability protection under Section 230 of the Communications Decency Act, which shields platforms from liability for user-generated content. So the liability cascade flows downstream, from the AI company, protected, to the freelancer, exposed, to the client, potentially exposed, but they'll fight it. And the freelancer is the least powerful player in that chain. I had a conversation with a venture capitalist last month who told me something that stuck with me. She said, the reason AI companies aren't building indemnification into their platforms is because it would cost them $2-4 billion in insurance and legal reserves annually. They've decided instead to let that liability sit with users. And as long as the volume of claims stays below a certain threshold, it's economically rational for them to keep it that way. That's the business model, unvarnished. The AI companies capture 85% of the productivity gains. The workers and clients fight over the liability. So what do you actually do about this? First, audit your current contracts. Go through every client agreement and every AI tool you use. Match them up. If your contract says original human-created work and you're using GPT-4 for any portion of that, you have a mismatch. Fix it before a client notices. Second, update your service offerings. Consider creating 2 tiers, AI-assisted work, cheaper, faster, and human-only work, premium, higher liability protection for the client. Price accordingly. Clients will self-select based on their actual risk tolerance, not based on what they think they should want. Third, get liability insurance that specifically covers AI-assisted work. As of early 2025, most standard E&O policies have exclusions for AI outputs, but there are emerging policies, Lemonade, Hiscox, some specialty underwriters, that are starting to cover this. It's expensive, but it's cheaper than $47,000 settlement claim. Fourth, document your AI workflow. If you use Claude to generate copy, then human edit it, then deliver it. Document that workflow. Keep the before and after. Show the edits you made. This creates a paper trail that shifts the calculus in your favor if there's ever a dispute. You're not pretending the AI didn't do anything. You're showing you added human judgment on top of it. Fifth, watch what's changing in the AI terms of service. OpenAI just updated their enterprise terms in late 2024 to include some limited indemnification for enterprise customers. That's a signal that the legal structure is shifting. It's shifting slowly, and it's shifting in favor of enterprise players first. But it's shifting. When similar protections come for SMBs and freelancers, that's your window to update your contracting. Here's the thing I've learned in my time building AI companies. The companies that win long-term are the ones that take liability seriously early. They build it into their pricing. They build it into their terms. They don't try to optimize it away. And the contractors and clients that win are the ones who understand that AI is a productivity tool, not a liability elimination tool. It makes work faster. It doesn't make it legally cleaner. So what's the actual path forward? I think we're going to see three things happen over the next 18-24 months. 1. Industry standards will emerge. Professional organizations, the Freelancers Union, industry-specific groups will create template language for AI-assisted work. That becomes the floor for what's acceptable. 2. AI companies will start offering tiered indemnification as a paid add-on. Want protection? That'll be 2-5% of your annual spend on the platform. This is already happening in early form with enterprise contracts. 3. Courts will start ruling on cases involving AI-assisted work and copyright infringement. Those rulings will clarify liability. And when they do, contractors who've already updated their contracts will be in a much better position than those who ignored it. The window to get ahead of this is now. It's not going to close, but the cost of updating your contracting, your insurance, and your workflow will only increase as more litigation happens and more case law gets established. So here's my advice. Treat AI-assisted work the same way you treat any tool that introduces complexity. Understand the liability, price it, disclose it, document it, and make sure your contracts reflect the actual work you're delivering, not the work you wish you were delivering. In my